Okay, it looks like we are on. Great.
Okay.
Okay. So, yeah, like you said, better late than never. Okay. Well, hi everyone. I want to welcome those that have joined us, whether it's been on Zoom or live. Today, I invited attorney Suzanne Graves to talk to us about long-term care planning and probate. And she also specializes in many other areas. But today we're going to be interviewing her on that aspect. To tell you a little bit more about her, she founded law offices of Suzanne Graves in 1995. Her firm advises clients in estate planning, probates, conservatorships, medical planning, VA aid and attendance planning, as well as tax, charitable, asset protection, and business planning. She graduated from Whittier College School of Law, and she has earned many rewards, and amongst that, the American Jurisprudence Award of Estate Planning and Legal Research and Writing. She's also an educator, contributing author of various estate and business planning books, and she's certified by the State Bar of California in estate planning, trust, and probate law. Okay. Well, thank you for taking the time to do this with me.
That's my pleasure.
So first I want to start by asking if you can tell us a little more about what the difference is between a will and a living trust.
Okay, well, clients oftentimes get confused by this because they think if they have a will that it's going to keep them out of the probate court, and that's not really what happens with a will. So there's a few differences, and there's a few things that we look at to determine whether or not a client needs a will versus a trust. So one of the differences is a will only becomes effective upon death, where a living trust becomes effective immediately when you sign it. So a will only handles things that occur after death, whereas a trust can handle things that occur during your lifetime. And one of the biggest things that a trust can handle during your lifetime is what happens if I become mentally incompetent and I can't handle my own financial affairs anymore. And so one of the things that we look at again, another difference between a will and a trust is that when you have a trust, there's actually a retitling of the assets. Everything's still held in your name, but you're holding it in capacity as trustee of your trust. As opposed to a will, everything's still titled in your name. And so what happens is if you have a will and you pass away, everything's still titled in your name. And so that's what forces people into the probate court. When you have a will, especially if you own real property, it's almost a straight ticket to probate because now you've passed away and you can't sign off on that deed anymore. So your family members, if they're going to sell the house or if they're going to go and refinance it, they can't do that because you're not there to sign the paperwork. So that's what kind of forces them into that probate court. So a lot of times a will equates to you are going through probate, and people think that if they have a will, they think it's going to keep them out of probate. So oftentimes what we find is what people really need is to have a living trust. And one of the things that we look at to determine whether or not they should have a will versus and a couple powers of attorney versus a trust is the asset level. If they have more than $166,000 in the state of California, then that's the amount that determines whether or not you go through a probate or not. So if they're under that and they don't own real property, then they probably can get by with a will and a couple powers of attorney. But if they own real property, or if that asset level goes over that $166,000 amount, then they really should have a living trust if they're trying to stay out of that probate system.
Okay, great. Okay, so when would you say that it's the right time for people to start planning for this?
Really, I always tell people I don't like to tell them to wait because things happen. People who are very young can get in accidents and need estate planning documents. Even if they don't have assets, sometimes they need to have their advanced healthcare directives in place or financial powers of attorney in place, even if they don't have a lot yet. And oftentimes with young families, if they have children, part of the estate planning process is determining, again, if they don't have a lot of assets, sometimes they might have just a life insurance policy to help provide for their children if something happens to them. Well, if you have minor children, there's no more important decision to make than who's going to take care of my children or handle their money if something happens to me. And so if you have minor children, you should have those decisions made. And so I like to see people, even if they don't have a lot acquired yet, to go through that process. We're working with a client right now who just called me a week ago. Her boyfriend had gotten into an accident and passed away, and they have together a 6-year-old child. Well, he named the 6-year-old child as the beneficiary of his life insurance company. And anybody who knows much about life insurance are going to quickly find out, if they're in that situation, the life insurance company is not going to pay that money out to a minor. So now the mother of this child is having to go set up a formal guardianship inside the court so that she can handle the money for that child. And more than likely what's going to happen is once that occurs, the court's going to order that money into a blocked account for the protection of the child. So now whenever she needs to use something for the benefit of that child, she's going to have to go in and petition the probate court in order to access that money to provide for the needs of the child. So there's a lot of court costs, attorney's fees, and expenses that go on between now and the time that child reaches the age of 18.
Oh, wow. Okay. So we do have someone, I don't know if you want to handle the questions at the end or as they come. We have a question that actually came in regards to that.
Yeah, you can go ahead and read the question now. That would be fine.
Okay. So it says, when those 166K are part of a 401K, does that still count? And how about life insurance payouts?
Okay, as long as they have a designated beneficiary on them and they're not going to minors, then that would not be included in that 166,000 because that's going to go by way of beneficiary designation. But just like I said on that life insurance case, if it's going to a minor, then you're going to have to set up a guardianship for a minor child. So in that case, we would rather do a living trust, make the designated beneficiary the trust to avoid that guardianship later on. The other thing is, it's really important to make sure that those types of assets have their designated beneficiaries on them, because if there's no designated beneficiary at all, guess what? The beneficiary becomes the estate, and the estate technically equates to got to open up a probate in order to get it. So it's really important to make sure that those types of assets have designated beneficiaries and to make sure those beneficiaries aren't minors.
Okay. All right. Okay. Well, that's good to know, because a lot of times people think that just because they think, oh, I don't have any money, but then if you have children, that's very important. Even if you wouldn't have any other like assets, it's important to have that in place. I know that there's been cases where, you know, that's been an issue where, you know, then if you don't leave someone assigned to, you know, how are you going to take care of your child, then it makes it difficult.
Yes.
Okay, so then my other questions are related to long-term care. What are the average costs of long-term care, and are there any government programs available to assist with that?
Yes, the average cost of nursing home care in the state of California is now $9,337 per month. So I always tell clients there's nothing that can dwindle away in a state quicker than a long-term care situation. It gets very costly for the family members. There is Medi-Cal assistance available to help people with that cost of care. However, that is a needs-based program. So, and in the level of assets that you can have on that program, there's a great difference if you're a married couple versus a single person. For a married couple, you can have $128,000 in assets and still qualify for Medi-Cal. For a single person, that amount is only $2,000. So that's quite a difference. And sometimes what we have is we have a situation where there might be a married couple, so they can qualify because they can have $128,000 of assets, but then sometimes it ends up being the non-sick spouse that ends up, has a sudden heart attack or something happens to them and they die, and boom, now that 128 automatically drops down to 2,000. So there's some planning that should be done in order to do that. There's planning that we can do to help people qualify for Medicare or Medi-Cal. And there are also exempt assets. So sometimes people think, well, if I have a home, especially in the state of California, I can't qualify. But your primary residence is an exempt asset, and you can have one vehicle, and you can have personal belongings. So there are some exempt assets, and there's opportunities to plan when it comes to those exempt assets.
So in regards to the exempt assets, how do you plan for those? Are you supposed to do something legally to protect them, or is there a process?
Well, first of all, a lot of times we want to protect those, because even though you can qualify by having the exempt assets, when you pass away, Medi-Cal has a recovery program where they can now go back after the value in that house after you die, as opposed to it going down to your family members where you might want it to go. And so again, it becomes really important to have a trust in place in order to avoid the probate process. It used to be that I always recommended that a client have an irrevocable trust in that case, because it got the asset out of their estate, so that when they died, that asset was no longer in their estate for Medi-Cal recovery. The law changed back in January of 2017, and basically it kind of took away the need to have an irrevocable trust to put your house in, but you still have the need that you need to have it in a revocable living trust, because basically what that law did was it said that Medi-Cal can only recover against probate assets. So now you could use your revocable living trust and have your house inside that trust. And when you pass away, it's still going to go where you want it to go, because it's not going to go through the probate process. But if that house is not inside a trust and it ends up going through that probate process, then Medi-Cal can file their claim through that probate process, and they can recover those assets.
So I guess this leads me to ask you, can you tell us a little more about the difference between a revocable and an irrevocable living trust?
Yeah, revocable living trust is basically, it's a trust meant to keep you out of the probate court in the event of death or in the event of disability. So if you have no planning done and you have a sudden stroke and all of a sudden you can't handle your finances anymore, and you don't have any planning done, it forces your family members into the court to get a conservatorship set up. And that is also governed by the probate court. So when you have a trust, there's a whole section inside that trust that says, this is what happens in the event that I become disabled. These are the people who can be cared for. Here's who I want managing my assets for me while I'm still alive, but I can't handle things on my own. But again, everything in the revocable living trust is geared towards keeping you out of that probate court, whether it's while you're still alive and you're disabled or after you pass away. With an irrevocable trust, you set that up and it's as if you're giving the assets away now. So there is a certain sense of loss of control because the assets are no longer considered yours. And so, oftentimes we might want to set up that irrevocable trust when somebody is going into a long-term care situation, because it's getting the assets out of their estate for purposes of determining whether or not they can qualify for Medi-Cal. Now, what happens with that is you still have to do a certain amount of planning, because it's not just as simple as throwing all your assets inside that irrevocable trust, because Medi-Cal has a look-back period, and if you have transferred assets out of your estate, then you have to wait a certain period of time, depending on how much you transferred, to determine when you can qualify for Medi-Cal. But for that type of planning, I will tell people the sooner you get started, the better. And there's also some things that we can do to shorten up those waiting periods. So we might strategize in the way that we get the assets out of the estate. But you can use that irrevocable trust to help people qualify for Medi-Cal. For instance, if they have more than just their home, but they have a bunch of money sitting in the bank too. And they're wanting to try to preserve some of that money and extend out so that they can help, extend their care out so that they've got money to pay for care so they don't run out, or for later on, if they want the money that they've worked hard for to go down to their children. So we can help preserve that. But there's a little bit of planning that goes into that, but that helps people qualify for Medi-Cal because the assets are actually outside of their estate.
Okay, and so let's say if someone has real property, they're a homeowner, and they have a long-term illness, and they have received Medi-Cal assistance, and then they die, what would happen since, if they don't have a living trust in place?
If they have no living trust in place, or they've done no planning, they are going to go through the probate process. And as part of that probate process, Medi-Cal is going to be notified that they've passed away, which anybody who, even if you have a trust or not, Medi-Cal will always get notified that the death has occurred. That is a requirement either way. But with Medi-Cal is going to be able to recover if there's a probate action. They will be able to file a claim and recover their money that they put out while you were alive through that probate action. Whereas if it's in a living trust, it never gets to the probate, and so it protects that home.
Okay, then we have another question. So when it's a property that's involved in probate court, what happens if there's still a loan on the house?
Okay, so typically what will happen is a lot of times that property will get sold through the probate process, and then that loan will get paid off at that time before it goes down to the heirs. Oftentimes what we find is that clients, especially if there's still money owing on the house, the children or whoever those beneficiaries are, they will usually open up that probate, and then once they get what they call letters issued from the court. And that's basically once the court appoints an administrator or an executor, then that person has the authority to go ahead and get the house listed and get it sold. And then that loan can be paid off. Sometimes we have situations where houses, once we get to that point, they're, you know, maybe the person who passed away hadn't been paying on their loan. And so the house might be going through a foreclosure action or something like that. And in those cases, what we can do is we will normally contact the lender and let them know that that person has passed away. And oftentimes we can work out extensions on that foreclosure to give people the opportunity to get the house sold. If the lender's not cooperative, we can take another step, which is we can go in on an ex parte basis into the court to say the house is in foreclosure and we need to stop this foreclosure. And usually the probate court will order the foreclosure stopped because of the probate. And again, that allows us time to get the house sold. And then once the house is sold, the lender gets paid off.
Oh, that's great to know, because I know that it could be where, you know, the kids or the beneficiaries might think, oh, you know, the house, we're just going to lose the house, and they might not know that there is something that can be done.
Right. And sometimes, and that's really important for them to know, because sometimes even though they might be behind in the payments, there's still equity in the house, and they don't want to just walk away from that. And you know, because sometimes that's what beneficiaries will do. They'll say, oh, well, the house is in foreclosure, so we're just going to walk away and let it get foreclosed on. But there's still money there. You know, if there's equity in the house, you know, they don't really want to do that. They want to still go through that probate process so that they can get whatever's left over there.
Yeah, great. Okay. So I have some more questions on a probate, but before I jump to that, I wanted to ask you about veterans aid and attendance benefit. Can you tell us more about that?
Yes, if you have a veteran who served during wartime, they are entitled to the Veterans Aid and Attendance Benefit. And that, just like with Medi-Cal, it's a needs-based program. But what they will do, in that particular case, you don't have to be in a nursing home. You could be living at home and having some in-home care, or being in an assisted living type situation. But they will pay out money every month, tax-free, to help pay for your care. So if you're dealing with, you know, a veteran, the veteran themselves, you know, and who's married, they might pay out $2,300 a month of tax-free money to help pay for your care. If you're a single veteran, you know, it's a little bit less, but they're still going to pay out that money. It's like $1,900 a month. For a surviving spouse, it's around $1,200 a month. So even if you're the veteran has passed away, but they have a spouse that's now receiving care, they'll pay out that money to help pay for that care. And it used to be, I really liked the old rules, because under the old rules, unlike Medi-Cal, there was no look back period. Unfortunately, that changed. They threatened for a long time they're going to change it to be in line with the Medi-Cal rules, and they didn't do it. And finally, you know, a year ago, last October, they changed those rules. So now it's more in line with Medi-Cal, where if you transfer assets out, there is a look back period. And so there might be a waiting period that you have to go through before you can qualify now. But it's still, that money coming in to help pay for care can really help somebody.
Yeah, yeah. So also, I was going to ask you, in regards to probate, now jumping back to probate, okay, how much time does it take, and how much would it cost if someone has to go through probate?
Okay, on the average in the state of California, it takes about 18 months to get through a probate. Sometimes it can go a little shorter than that. You know, if someone's on top of it and really moving that probate along, you could get it closed sooner than that. But with probate, you're always going to have to go in, petition that probate court. You're going to have to, once someone gets appointed as the administrator of the estate, there's a notice that goes out to creditors. So you have to wait 4 months in which for creditors to file claims. If there are creditors that file claims, then those claims either have to be paid or negotiated and then paid before you can close the probate. Sometimes there's certain objections that occur or a sale of a home that has to occur through that probate. So there's things that have to happen before that probate can actually close. And so, so a probate can go on for a period of time. Now, we're kind of working a little bit of uncharted waters right now because we have a situation where the courts are closed right now. And so all the hearings that were in place are getting continued. So for instance, I had a hearing earlier this week and it got continued to June 3rd. Okay. And now in the meantime, we've got more filings that are occurring, and those filings, because there's nobody in the courthouse working right now to process those filings. So I'm assuming what's going to happen is they're probably going to come in as they're postmarked for those filings. And when they get back, they'll start processing those filings and setting hearings. But I have a feeling that there's going to be a little bit of a backlog there when the courts do get back to work. So it might extend the time that it takes a little bit to go through that court process. And the other unknown is we really don't know how long the courts are going to be closed yet. I'm hoping that if we get to the end of April, because right now that's where in San Bernardino County, at least they're saying we're closed until April 30th now. Okay, if they don't open on April 30th, I'm hoping that they'll do some kind of alternative thing, like, you know, maybe because there are, you know, you can do court appearances by court call. So I'm hoping maybe they'll do telephone appearances and things like that so that we don't get too backlogged on everything. So I don't know. I'm sure they're considering options like that, I would assume.
Yeah, hopefully, because I can only imagine, you know, the backlog. Oh, wow.
Yeah. The courts are backlogged enough without all of this, right?
Right, yeah. So we do have another question in regards to a home and equity. It says, when the property is involved in probate and doesn't have equity and the loan is negative, are the heirs responsible for that negative balance, whether there's a will or a living trust?
They are not responsible. The estate is responsible. So if there's money in the estate would have to pay for that, or we can always go in and try to negotiate for a lower amount. However, the estate is responsible, but the heirs don't become responsible out of their own pockets with their own savings to take care of that.
Okay, all right, that's good to know, because, you know, that could be a fear of some of the heirs where they might think they're going to be held responsible. Can you tell us a little more about a bond? When do they need a bond and when it's not necessary?
Most times a bond is required. However, when someone does have a will, they can waive the bond. And if the bond is waived in the will, most times the courts will say, okay, it's waived inside the will, so we don't have a bond. However, there are some circumstances where the court will still require a bond. So one of those circumstances is if you have an administrator who lives out of state, the court will usually still require that there be a bond. The other thing is if the will doesn't waive a bond, or if there is no will at all, the beneficiaries, which if there's no will at all, it's going to go through the laws of intestate succession. So what I always tell clients is, if you don't have a plan, the state of California has a plan for you. And those people that are the beneficiaries, they can waive the bond. So if everyone waives bond, then the court might say, okay, they all waived bond, so we're not going to require it. Sometimes it depends on how much money is in the estate. You know, sometimes if there's only a house inside the estate and there's no cash, it's hard for people to just get up and walk off with real property. So the court will say there's no bond required at this time. But once you sell the home and you turn that into cash, at that point in time, the court might require the bond be had.
Okay, all right. And then when someone's gonna, when they're getting a living trust prepared and they need to choose who their personal representative is, what do they need to consider, and what are the duties and responsibilities of the personal representative?
What I tell clients is that's actually one of the most important decisions that they're making when they're doing their estate plan. Because first of all, that trustee or the executor, if you're doing a will, that person has a lot of power under your document. And so you want somebody who's trustworthy. You want somebody who's going to be able to communicate well with the beneficiaries of your estate. You know, a lot of times, you know, a lot of people have never been through the probate process before, or even been the trustee of a trust before. And so even though they might be trying to do the best they can, they might not always do everything just right, especially if they're not seeking legal help to do it. And a lot of them, when they first get involved, they don't really know what's involved. And, you know, it's one of those things, they don't know what they don't know. And so, you know, and then the same thing with the beneficiaries. They don't know what they don't know. So we've got a trustee who all of a sudden they have to inventory the estate. They have to place dates of death values on all the assets. There's legal notifications that need to go out. There's tax returns that need to be filed. And we want somebody who's going to have some good record keeping abilities, because they're going to need to account to the beneficiaries for everything that comes into the estate and everything that goes out. And then there's some rules they need to abide by, like they can't commingle the assets of the estate with their own assets. That's a big no-no under the law. And so there's things that they need to know. And a lot of times what they do is they start acting and they learn, you know, as they're going along, either because they're being represented legally or they're being guided by somebody. They learn that, oh, I have to do all these things. Well, all these things take a little bit of time, okay? The beneficiaries are going, what's going on? Where's my money? How come I'm not getting it? And if they can't communicate well with those beneficiaries, the beneficiaries then all of a sudden think, well, they're not telling me anything. Something's up here. Something's wrong, you know? And so you want somebody who's going to have some good communication skills, who's able to communicate back with the beneficiaries about what's going on and why it's taking, you know, the amount of time it's taking and things like that. So that, because a lot of times that lack of communication is where problems start occurring. And then, you know, you have the beneficiary saying, you're not doing your job. And this person's like, this is like a full-time job on top of my own job, and I'm doing all these things and you're so ungrateful, you know? And so there's a lot of going back and forth that can be avoided with some communication.
Yeah, I can see where that would be important, especially if the beneficiaries are not getting the right information or answers to their questions, where they could get frustrated. And then at the same time, where the personal representative can get frustrated too, because they're trying their best to do what was in the trust. So yeah, I can see, you know, as it is, they're probably, you know, probably going through, you know, some grieving and emotional stuff and, you know,
Right.
stress and things like that.
Yeah, and that's
Yeah.
the other thing that someone needs to consider when they're naming who that trustee is going to be, because is it somebody who's going to completely be falling apart because they've lost you, you know, because they're just going through the emotional end of this, or is it someone who you look at and say, oh, you know what, it might not be easy for them, but they'll be able to continue on and carry on. It's not going to just like stop everything. You know, so different family members have different personalities and how they react to things. So all those kinds of things kind of come into play.
Yeah, yeah.
I tell people that the same kind of analysis goes into their advanced healthcare directives and who's going to act as their agent under their advanced healthcare directive. Because again, if you're directing somebody, hey, I don't want to be on life support and you need to remove it, you know, you might look at some of your kids and say, they'll know my wishes, but they're going to absolutely fall apart and not be able to do this. Where they might look at another family member and say, yeah, again, they might not like it, but they'll be able to follow through and carry through with this wish.
Yeah, and that reminds me, just yesterday we were listening to the news. My mom and I were listening to the news, and they said something about health directives. And I said, that's what I want, Mom, when, you know, that's what I have in my trust. And she goes, no, you know, so definitely I wouldn't want her to have, you know, be the one to have to make the decision or handle that.
Exactly. And that's exactly what happens.
Yeah, yeah. So, you know, so then, you know, talking about that, with everything that's changing right now, with, you know, the COVID-19 and, you know, everything's changing, and, you know, there's things also changing in the legal field as far as estate planning and long-term care and all that. What type of things are changing in estate planning?
Well, one of the things are people are really taking a close look at those advanced healthcare directives, because one of the things that we're seeing with the COVID-19 is there's people that need to go on ventilators, and that is a form of life support. And so some people are rethinking those advanced healthcare directives a little. And there's really a process that you need to go through when you're thinking about that, because what a ventilator, you know, and there's limitations on what a ventilator can and can't do. When they put you on a ventilator, they put you into a medically induced coma when they do that. And it's really there to bide time, and it delivers oxygen to your organs when they're not getting enough oxygen. But it doesn't cure the virus, okay, and some of the effects of the virus. And sometimes when you're on that ventilator, your kidneys can start shutting down and things like that. And so people are really rethinking, especially with this coronavirus, is, you know, there's young people that are having to go on ventilators, and is that what they want? Number one, you know, because people are having to make these decisions at a time where they're sick and they're feeling like they can't breathe, and they're having to make quick decisions on these things. And the other kind of bad thing about it is that they're having to make these decisions alone, because their family member can't be sitting there holding their hand at the time, because you know, they have because of, you know, the infectious state of this whole thing, people can't be with them. So they can't be there with their loved ones when they're making this decision. And so it's something that we're telling people, you want to think about what it is your wishes are, and you want to get that documented now so that you're not having to do that at a time when you're sick, and you're wanting to let your family members know what that decision is so that they know ahead of time, and then really kind of evaluate at what point, somebody might say, if I get this, I do want to go on the ventilator, but maybe I want the discussion with my doctor first about how bad are my lungs at the time and is it going to work? And at what point do I want it taken off? If my kidneys start shutting down, do I want it removed at that point? Things like that. And then, the other kind of thing is, it's important to make these decisions now too, because, ventilators are in short supply. And if you have somebody who says, I really don't want to be on a ventilator, and I want that decision known and I don't want to be on it, then leave that ventilator for somebody who does want to be on it, because there's a shortage of them right now. So those are all kinds of things that are coming up and being discussed. And people should update those advanced healthcare directives, or if they don't have one, make sure that they do have one in place, because as we know, this virus doesn't, yes, it may have a larger effect on the older population, but it's, it doesn't discriminate. There's younger people that are getting it too. And so people need to be prepared.
Yes, and this definitely caught all of us off guard, where those that don't have a health directive should probably think about one, and those that have it might need to make some changes to it.
Right.
So let me ask you about nursing homes. How can, is there anything that people can do, or in regards to the nursing homes not allowing visitors because of the virus? And then how can someone monitor their loved one's care in a nursing home if they can't visit?
That's another area that's come up just in the last few weeks, because of COVID-19, nursing homes are trying to keep their residents safe. And so they're trying to keep people out of the nursing homes where you can't just walk in and visit anymore. And what my experience has been, I've seen in the last couple of weeks, I've had people who have clients in nursing home care that are in an assisted living situation where they are no longer allowed to visit them. But if those people get close to passing away, then they let people come in one at a time to kind of say their goodbyes to them. And so that's kind of what I think the new norm is right now. So people have asked, can the nursing homes really keep us out so we can't see our family members? And the answer to that is yes, because of this pandemic. And there are certain things when it comes to keeping the public safe and health situations. There are orders that can come down from the government that limits access for things like that. But what I tell people, and so one of the concerns is that you don't have your normal inspections of a nursing home that you would normally have because people are staying out right now. Or, how do you know that your loved one's being properly cared for and things like that? So, again, I tell people, make use of modern technology. If you can FaceTime and FaceTime your loved one, it's not as good as being there, but it's some type of contact, and you can see what's in the room. Is the room being kept clean? You can try to monitor and the situation. Again, sometimes that becomes difficult depending on the level of care the person needs, because sometimes they might not that person inside that nursing home might not be able to do those things. But you can still contact that nursing facility. And if you have complaints, you can still file your complaints against that facility, but you need to try to monitor it as best as you can, you know, through modern technology, and try to stay in touch that way. And
Yeah,
hopefully
so
this doesn't go on too long.
right, yeah, I know. So now that you bring up the technology, how are people signing their documents with the stay-at-home orders that are in place right now?
Okay, the state of California has not been real good with this, but like for instance, when this first all started, Florida came in and they did a law where you don't have to notarize a document personally, that you could do it through technology. And so I was kind of hoping that California would follow that suit, but they haven't. And I've heard some people say California is never going to do that because of all the fraud that goes on. That's just not going to happen in the state of California. So right now, we're just doing the best that we can. A lot of our meetings, we're either doing Zoom meetings or we're just having telephone conferences with people. And a lot of my work I'm doing from home, some of my work I'm doing in the office, but I am going in the office to meet with people when they do need to sign their estate planning documents, because they have to be notarized. And if they don't want to come, you know, we can set up where a traveling notary can go out to them. But again, you know, it's one of those things where you just do the best that you can in our circumstances. But unfortunately, the state of California still requires the notarization to be done in person. So I guess if this goes on for any extended period of time, maybe that will change. I'm not sure. But right now we're just doing the best with what the law is.
Yeah, wow. Okay. Well, this all has been very helpful. Especially around this time when, it's uncertain times, and a lot of people are facing different things. Unfortunately, there are those people who have gotten sick, and others who have passed away, even though, like personally, thank God I have not, but there is a lot out there. So I think all of this information is really helpful for people to be ready and get prepared, because we might think that's not going to happen to us, but we never know. Better to be safe than sorry.
Right, you never know. And one other thing I would like to give, Lupe, is there's an Access Hotline that I want to give out the number for, because it's a statewide hotline for the state of California. And if there are people out there that have questions, or if they need some type of assistance, people who are out there who need help getting their groceries or medication, they can call this hotline and they can help them. And so a lot of our elderly people, they might need help with those kinds of things, and people who aren't able to get out as much. So that Access Hotline number is 833-544-2374. So again, it's 833-544-2374.
Oh, great. Okay, that's great. Thanks for that information. So we are towards the end of our webinar. Is there anything else that you would like to add before we end?
No, I think that's about it. Like I said, we're still open for business. I'm grateful that we're still able to do that and still able to help people. And like I said, half of it's from home and part of it's from the office anytime. Most of my staff is working remotely from home. But if anybody needs assistance, they can give us a call. And if they get our answering machine, we will call them back. But our number's 909-981-6177.
Okay, great. Can you repeat it again, just in case?
Sure, it's 909-981-6177.
Great. Okay. Well, thank you so much. I really appreciate your time, and maybe we can do another webinar in the future about, I don't know, maybe business planning or some of those other areas that you have expertise in.
Sure.
Okay.
All
Well,
right.
thank you. Thank you so
Thank
much.
you. All righty.
Okay. All right. Bye-bye.
Bye-bye.